morning and a warm welcome to our 2016 Employment Law Briefing. And thank you all for coming along this morning.
It's fantastic. It's a broad range of individuals. There's legal people here, there's HR professionals, and it's, there's a lot of local businesses here, and that's really important.
Good morning, ladies and gentlemen. Data Protection Act, not the most exciting act, but it's one that affects us greatly.
My favourite speech was the Data Protection Act.
They seem to be mind readers, so whatever comes up here is actually things that we're dealing with in the workplace.
As a lawyer, I find whenever I want information, the normal response I get from anybody is I can't tell you because I'm affected by data protection. So we all use it as an excuse to stop looking for information which probably could be given out quite legitimately. If we see a client that's aggrieved about what's happening at work, prior to them even raising a grievance or anything happening, recommending them to submit a subject access request is really a good way of getting the information going. And that information is everything that is personal data about that employee. And time again, with emails, we respond very quickly. You're in work, somebody asks about somebody in your department and you say he's a waste of space, I wish we could sack him. That goes and files away. Somebody says, I didn't tell him at his appraisal how rubbish he was, but he really is a waste of space. All of those documents will come out.
I've never sort of been to anything like this before, so it's a bit of an eye-opener. I'm still digesting the information.
In tribunal cases, as I say, you have less information, but you've got to produce other documentation which you might not want to, but in a subject access request, you've got to give everything. So even if they are mentioned in a report, they'd be entitled to a copy of it. The motive isn't relevant. As far as the Information Commissioner's Office is concerned, the data right is to know what is being stored by your employer about you. Courts look at it somewhat differently. They take the view that if it's a fishing expedition, they won't necessarily order the company to do it.
It generalised a lot of information and gave you a good broad aspect, I suppose, or perspective on the current law and some of the law cases that have come up. So, yeah, it was interesting in that respect, yeah.
What you might want to rely on is legal privilege. There are some exceptions. Now, lawyers at the moment, we're under attack by everybody. Nobody's got any time for a lawyer. There's talks that legal privilege should be removed. If you come to see us and tell us something because you're trying to get information in an employment matter, we can't be forced to reveal that information. You don't have to produce what I send to you as part of any information, although it will refer to your employee, Mrs. Jones. Accountants don't get legal privilege, HR officials don't get legal privilege. So many companies will use an HR official, they'll correspond, when it starts litigation they come to the lawyer to deal with the tribunal. All the correspondence that went on in the early days, we must get this right, we mustn't be conned in the disciplinary, we've got to do this in the disciplinary, you could have produced against you.
Thank you very much indeed to Martin and Tim. I did say at the beginning that I thought their presentations were straightforward, relevant and realistic to our working days, and I think they proved that again today, so thank you very much.